How do bankruptcy trustees get paid? I'm here with Luke Homan, one of the top bankruptcy attorneys in Oklahoma. Luke, open this up for us.
All right. So this is so fascinating because this really, I think, gets you the key insight into how a Chapter 7 trustee thinks. So let's talk about our regular mundane bankruptcy. Jack and Jill file, they're broke, they have no assets. The trustee runs the hearing, looks at the documents, and there's no money. That's a lot of bankruptcies.
Mhm.
The trustee will issue what's called a report of no distribution. None of the creditors get any money, and the trustee gets paid $60. 60
For the entire Chapter 7 bankruptcy?
for that entire case.
60?
60.
Okay.
Right. That fee was set in like the 1970s, and it's never been updated.
$60. Wow.
Trustees are trying to get it up to 120. But you pay that out of your Chapter 7 filing fee. Your Chapter 7 filing fee includes the money the trustee gets paid.
Is that the file, that 338 filing?
38. The reason why it's higher in the 7 is because some of that money is going to the 7 trustee.
Okay.
So the court system will issue the trustee $60.
Wow.
So if you think about, in a very selfish way, how much time does the trustee want to spend on Jack and Jill who are completely broke? Well, they want to get their $60 worth.
Yeah.
They want to do the things they need to do, but this is not a high-paying adventure. This is the trustee doing their job and collecting their $60 for Jack and Jill who are clearly broke.
Well, and especially because most of the time you're talking, they lost a job, they had a medical problem or a car accident or something. They literally have no money, and there's no reason to spend time searching for money because they don't have money, right?
Yeah.
They're not using the system.
Now let's change the story.
Yeah.
All right. Jack and Jill lost their job, but they had a Corvette. They had their Dodge Neon and their Toyota Corolla that they used to get to work, and they got this Corvette on the side. But they've $100,000 of debt, $200,000, whatever. All right. The Chapter 7 trustee is going to take that Corvette, give it to the auctioneer, sell it, and turn the Corvette into money for creditors. Let's assume also that no attorney work is necessary on that case. The Chapter 7 trustee is going to get paid a statutory commission. This is on a sliding scale. So if it's a case that involves a small amount of money, less than $5,000, I think, the trustee might get 25%. If the case involves millions of dollars, they might get less than 1%. So it's a complex kind of sliding scale.
Okay.
But the idea is the trustee is doing work. They are doing work that benefits the creditors. They are going to have to administer claims. They're going to have to pay creditors. They're going to have to get court orders. And so for that, the trustee is getting a commission. So the trustee is trying to determine very quickly, is this a case where I'm going to get $60, or is this a case where there's work to be done and there's more money to be made? Now, let me throw something else at you. Sometimes there's legal work that needs to be done. And so the trustee might hire a attorney, 6 different law firms. I mean, usually it's one attorney. If the trustee is attorney, oftentimes they employ themselves. Now you're in a situation where if there's legal briefing, drafting, arguing that needs to be done, the attorney, who's also the trustee, can bill at their hourly rate.
Okay.
Now, that's going to be subject to Department of Justice review and court approval. So just imagine a case where they take the Corvette, but then there's an argument about whether the lien is valid. And so they've got to brief this and argue in front of the judge.
Yeah.
So maybe they bill for $2,000 worth of legal work, and then on top of that, they get paid the commission. In some parts of the country, the trustee may not even be an attorney, so they hire a separate attorney to do that work. Or in some parts of the country, the trustee can't hire themselves.
Got it.
So you really got kind of 3 styles of compensation, if you will, in a bankruptcy case.
So let's unpack each 3. So the first step, Jack and Jill, simple case, no assets, something like that. The trustee gets paid $60, and what they're really looking for is abuse. Are these people trying to abuse the system?
Is there abuse? Is there assets? Have we complied with all the requirements? If we're hitting all the requirements and there's no abuse and there's no money, close the file, get your $60.
On the second set, the Corvette, right?
Right.
If the client explains this to the bankruptcy attorney that they have this Corvette, right? Do they know going into the bankruptcy that they're gonna have to sell it? Is that fair to say?
Yeah, the trustee's gonna or I'm sorry, not the trustee, the bankruptcy attorney. They'll lay all these scenarios out for them. You're allowed to exempt vehicles. And in every part of the country, it's different, right? In Oklahoma, it's $7,500. In other parts of the country, it's less. So that's why in that example, I said, okay, you got your Dodge Neon, you're protecting, and you got your Toyota Corolla, you're protecting, because there's always some provision for this car is necessary to get me to work.
Yep, absolutely.
But that's why I'm using a Corvette that's kind of this luxury car that isn't necessary. And so, well in advance of filing the bankruptcy, any bankruptcy attorney is going to be able to spot, that's a luxury item.
That's all. So
That,
so
let's figure this out.
so what if the debtor sold the Corvette before the bankruptcy?
I would be very, very careful about that.
Oh, you would?
Not to say that it can't be done or shouldn't be done, but it's going to be different in every part of the country.
Okay.
So get a good bankruptcy attorney, talk to them, figure it out, and it may be able to be done.
Or maybe able to be done, and maybe it'll be saved, or you're gonna have to sell it, but you do it through the bankruptcy.
And it's also often one of those things where sometimes people are so far in debt that the money they get from this Corvette is not going to come close and off their debts. Or in reality, there's a Corvette, but there's also a lien on it. So even if you sold it, and it gets complicated, and sometimes the debtors just say, you know what, I can't even figure this out, and it's a mess, and I file bankruptcy.
I can't tell you how many times I've heard and I've seen our clients hold on to things because it's like, "Oh my god, I can't sell the Corvette. Oh my god, I can't sell the Corvette." And when they end up getting rid of the Corvette years after they've been thinking about it and thinking about it, whether you're the freedom they feel
Right.
from not having the Corvette, it's like, "Oh my goodness."
Right.
Yeah.
Let's
Like,
listen to the words of wisdom of Elsa.
uh,
Let it go. Let it go. Let it go.
telling you,
Let it
yeah, there's a piece to that.
go.
Okay.
It is.
And the third example is legal work, right?
Yeah.
Where there's more work associated with the bankruptcy. Go ahead.
Yeah. So let me give you an example of a case I was involved in recently. The debtors had bought a minivan and they financed it with major national financing company. The major financing company didn't place their lien properly on the minivan.
Mhm.
So the trustee went and stripped the lien off the minivan. It took a lot of legal work. And the lender had just messed up. They didn't do their paperwork. And so they didn't actually secure it. It wasn't truly a secured debt. And so the trustee stripped that lien off. And then in this case, the trustee said, okay, debtors, you can either buy it from me for this value, or I'll just auction it off. And in this case, the debtors just said, you know what, we don't even need a minivan anymore. Auction it off, and that money goes to creditors. So basically what the trustee did there is they took the lien, did some legal work, said, okay, major company, you messed up. So now I've got this minivan. Trustee sold it for $33,000. And that money went to all of the creditors collectively.
But does a percentage go to that lien holder of the minivan or not?
Yeah, because they filed a proof of claim. They're a creditor just like everybody else.
But they didn't have
They're a creditor anymore.
it wasn't first dollar and first dollar to them because it wasn't secured anymore.
Right, exactly. Normally, if it's properly secured, they would have gotten all the money from the minivan. But what really happened behind the scenes is the car dealership, I think they were doing some shady things. And so they didn't do their paperwork. And who did it hurt? Well, it hurt them. They still got some money from the case, but they didn't get a minivan.
Yeah.
They got a distribution.
This is why we say do not go to these buy here, pay here dealerships. There's plenty of good dealerships you could go to
Also,
that are reputable.
get yourself a good bankruptcy attorney.
Yeah.
The bankruptcy attorney can spot that issue. And in this case, the clients did not care. They didn't want that minivan. It was a bad choice to begin with. But the trustee did a bunch of legal work. And as a result of that legal work, there were attorney fees, there was a trustee commission, and the creditors all got
Mhm.
a piece of $33,000.
How much did the trustees make on that? Like on that $33,000 sale?
My guess is about $4,000 is the
Okay.
trustee commission.
Okay, got it.
Huge difference from that $60 case.
Yeah.
Now they found a lender mistake, a lien issue, a shady deal. And because the trustee had to auction this thing off, he had to cut checks, he had to do X, Y, and Z, the statutory commission for the trustee wound up being $4,000 $50.
Wow. Okay. And then all the creditors love that. The other creditors love that.
Right.
Because it automatic they found 33,000 or $29,000
Yeah,
to pay.
right. So,
So
and did the debtor pay a dime? No, they didn't.
yeah, so the cost of the debtor or the client filing bankruptcy, there's no difference. The whole thing is the reason why, and I've never really thought about this, but the reason why probably the bankruptcy codes were written this way is to align the interests to make sure that the trustee, hey, if someone doesn't have a lot of money, like a normal
Right.
Chapter 7 debtor, look, it's okay. Don't worry about it. You're gonna make $60, but that is what it is, and you're moving on.
Right.
But be on the lookout for people who are doing fraudulent things.
Right.
You want to be on the lookout for people who are abusing the system, both on the client side and the creditor side.
Right.
And then through the intellect of the trustee, you can spread out the
Yeah.
money accordingly.
Now, sometimes the client will see this court file and they'll say, trustee's getting $4,000. I got to pay the trustee $4,000.
Yeah.
No,
Yeah.
the creditors are paying the trustee because the trustee is getting them money.
Yeah. Wow. Very insightful, Luke. Luke Homan, one of the top filers in bankruptcy from Oklahoma. Luke, thanks again for your knowledge.
Yeah, absolutely. This is fun.